from a former Jackson County deputy sentenced to 12.5 years in prison for planting drugs during traffic stops, leading to the dismissal of nearly 120 cases.
There were 3 possession of drug paraphernalia counts, misdemeanors.
To a Kansas City officer receiving concurrent sentences for fatally shooting a man during an unwarranted backyard confrontation.
Cameron Lamb is dead. And Eric DeValkenaere killed him.
Here are 5 times corrupt cops reacted to their death sentences, starting with the shocking case of Officer Zachary Wester.
Sure. This court now sentences you as follows in this case. As to count 1, racketeering, which is a first-degree felony, you are sentenced to serve 5 years in the Florida Department of Corrections. As to count 7, official misconduct, as a third-degree felony, you are sentenced to serve 18 months in the Florida Department of Corrections. That will be served concurrent with count 1. As to count 9, official misconduct.
This is former Officer Zachary Wester from the Jackson County Sheriff's Office. On July 14th, 2021, Officer Wester faced the court for the 67 charges of racketeering filed against him. Officer Wester systematically used traffic stops to falsely incriminate individuals by planting drugs and claiming to smell marijuana as a pretext for vehicle searches. He planted substances like methamphetamine or marijuana and falsified evidence, including drug test results, to build cases against his targets. His misconduct led prosecutors to drop nearly 120 cases he was involved in, exposing the extent of the injustice he caused. As a result, Officer Wester faced multiple charges, including racketeering, official misconduct, perjury, fabricating evidence, possession of controlled substances, possession of drug paraphernalia, and false imprisonment. Watch how the sentencing unfolds.
Set forth today and is set forth in the attached pre-sentence investigation. The court has considered all of those things when determining what a proper sentence should be in this case. And the court has heard the argument of the state that they are requesting 15 years in the Department of Corrections, and the argument of the defense that they are requesting something closer to the 81.5 months that is set forth in the score sheet. Court, I guess it has some flexibility under Florida law to go under, but it's a tough hurdle or a tough thread to bear to get under that score sheet. But the court also has discretion in this case to go above what's recommended by the state. And so that needs to be put on the record today. The court has liberality in that regard. At this time, I'm going to go ahead and adjudicate Mr. Wester guilty. I am going to go ahead and give Mr. Wester 58 days jail credit in this case. There are court costs and fines of $1,065. And I'm going to go ahead, Mr. Wester, if you'll step up, I'm going to get you fingerprinted at this time, sir. Sure. This court now sentences you as follows in this case. As to count 1, racketeering, which is a first-degree felony, you are sentenced to serve 5 years in the Florida Department of Corrections. As to count 7, official misconduct, as a third-degree felony, you are sentenced to serve 18 months in the Florida Department of Corrections. That will be served concurrent with count 1. As to count 9, official misconduct, a third-degree felony, you are sentenced to serve 18 months in the Florida Department of Corrections. That is consecutive to count 7. As to count 10, official misconduct, that is a third-degree felony. You are sentenced to serve 18 months in the Florida Department of Corrections. That is consecutive to count 9. As to count 31, fabricating evidence, that is a third-degree felony. You are to serve 1 year and 1 day in the Department of Corrections, consecutive to count 10. With respect to, as to count 33, that's fabricating evidence. That's a third-degree felony. You are sentenced to serve 1 year and 1 day in the Department of Corrections. That will run consecutive to count 31. As to count 34, that's fabricating evidence. That's a third-degree felony. you were sentenced to serve 1 year and 1 day in the Department of Corrections. That is consecutive to count 33. As to count 41, possession of a controlled substance, that's a third-degree felony. You were sentenced to serve 1 year and 1 day in the Department of Corrections. That is consecutive to count 34. As to count 44, that's possession of a controlled substance, that's a third-degree felony. You were sentenced to serve 1 year and 1 day in the Department of Corrections, consecutive to count 41. As to count 48, possession of a controlled substance, that is a third-degree felony. You are sentenced to serve 1 year and 1 day in the Florida Department of Corrections. That is consecutive to count 44. With respect to as to count 64, that's false imprisonment. That's a third-degree felony. You were sentenced to serve 1 year and 1 day in the Florida Department of Corrections, consecutive to count 48. As to count 65, false imprisonment, that's a third-degree felony. You were sentenced to serve 1 year and 1 day in the Florida Department of Corrections, consecutive to count 64. Counts 7, 9, 10, 31, 33, 34, 41, 44, 48, 64, and 65 are to be served consecutive to each other for a total sentence in this case of 12 years, 6 months, and 8 days in the Florida Department of Corrections. This sentence of 12 years, 6 months, and 8 days in the Florida Department of Corrections is to run concurrent with a 5-year Department of Corrections sentence in count 1. Therefore, it is the intention of the court that you are sentenced to serve a total of 12 years, 6 months, and 8 days in the Florida Department of Corrections. I'm also going to award the defendant 58 days jail credit as to count 1 and count 7, as count 7 is the first sentence served by the defendant in a series of consecutive sentences. Finally, as to the remaining misdemeanor charges, you were sentenced to serve 58 days in the county jail with credit for 58 days as to the following counts. That would be count 19.
Officer Zachary Wester received a prison sentence of 12 years and 6 months after being convicted on multiple charges, including false imprisonment, fabricating evidence, official misconduct, and possession of controlled substances. Many of these offenses were third-degree felonies. He was convicted in 19 out of 67 counts against him. If you think this was the only cop who got to react to their death sentences, wait until you watch this next case.
Cameron Lamb is dead. Eric DeValkenaere killed him. And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation.
This is former Officer Eric DeValkenaere from the Kansas City Police Department. In March 2022, Officer DeValkenaere faced the court due to the killing of an innocent citizen. On December 3, 2019, Cameron Lamb was fatally shot in a confrontation involving Officer DeValkenaere. Earlier that day, Mr. Lamb had been pursuing his girlfriend at high speeds that allegedly endangered public safety. After ending the chase and returning to his home, he began parking his truck in his driveway when officers, including Officer Eric DeValkenaere and Sergeant Schwalm, tracked him to his residence. The officers entered Mr. Lamb's backyard without a warrant and confronted him. Officer DeValkenaere claimed he fired his weapon after seeing Lamb with a gun, believing his partner was in danger. This incident led to Officer DeValkenaere being charged with manslaughter and armed criminal action. Observe as the judge delivers his verdict on the case.
However, those events tragically concluded with the actions of Troy Schwalm and the defendant. Pulling up to defendant's house, Sergeant Schwalm pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option, without so much as a, "Hey, Troy, wait." At any point, Sergeant Schwalm and the defendant could have done this, a fact that is made even more aggravating as the court considers an appropriate sentence, in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway under the carport and into his garage. Then Sergeant Schwam and Eric DeValkenaere arrive, and as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. The circumstances of the offense as described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValkenaere, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house. Although not in the court's view, again, rightly or wrongly, negating his obligation to act with reasonable care, as the court found he has failed to do, his natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction. I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things. Eric DeValkenaere is not Derek Chauvin, who murdered George Floyd. Eric DeValkenaere is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality of the defendant's life. The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him, as it did on December 3rd of 2019. All of which, however, leads the court back to where it began, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family. Cameron Lamb is dead. Eric DeValkenaere killed him. And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause, having been shown, why sentence and judgment of the court should not now be pronounced.
None from the state.
No, sir.
Eric DeValkenaere, on count 1, the Class E felony of involuntary manslaughter in the second degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
The judge sentenced Officer Eric DeValkenaere to 3 years in prison for the Class E felony of involuntary manslaughter in the second degree and 6 years in prison for the unclassified felony of armed criminal action. Both of these charges will run concurrently. If you think this was the height of a corrupt officer reacting to their death sentence, then you probably haven't watched this next case.
We, the jury, being duly empowered and sworn,
to find the defendant Adam Coy guilty of murder as he stands charged in count 1 of the indictment, signed this 4th day of November 2024, and what appeared to be 12 signatures. Second count, we the jury being duly empowered and sworn to find the defendant Adam Coy guilty of felonious assault as he stands charged in count 2 of the indictment.
This is former Officer Adam Coy from the Columbus Police Department. On November 4th, 2024, he was present inside the court waiting for the sentence to be announced related to a case that unfolded on December 22, 2020. Officer Coy responded to a non-emergency call regarding a suspicious vehicle in the area. During the incident, Andre Hill, who was visiting a friend, approached the officers while holding a lit cell phone. Mr. Hill made no threatening movements, yet within seconds, Officer Coy fatally shot him, claiming he believed Mr. Hill was armed. No weapon was discovered at the scene.
My understanding that you have reached a verdict in this matter? Yes. Okay. Mrs. Harper? As to count 1, we the jury being duly empowered and sworn to find the defendant Adam Coy guilty of murder as he stands charged in count 1 of the indictment, signed this 4th day of November 2024, and what appeared to be 12 signatures. Second count, we the jury being duly empowered and sworn to find the defendant Adam Coy guilty of felonious assault as he stands charged in count 2 of the indictment, signed this, and what appeared to be 12 signatures. The next verdict form. We, the jury, being duly empowered and sworn to find the defendant Adam Coy guilty of reckless homicide as he stands charged in count 3 of the indictment, and what appeared to be 12 signatures. Does anyone wish the jurors to be polled?
No, Your Honor.
No, Your Honor.
All right. Ladies and gentlemen, thank you very, very much. Your civic responsibility and being here and handling this matter. In a moment, I am going to excuse you back to the jury room. At that time, I'm going to ask if you would please wait so that I can come back and thank each of you personally. All rise for the jury.
Officer Adam Coy was convicted of murder, felonious assault, and reckless homicide in the fatal shooting of Andre Hill. Notably, Officer Coy's family was absent from the courtroom when the verdict was announced. If you think this was the height of cops reacting to death sentences, then you probably haven't heard of this next case.
There were no winners at all in this situation, not only for myself and my family, but for all of those involved.
This is former Officer Michael Notoriano from the St. Clair Shores Police Department. In April 2018, Officer Notoriano was present in the courtroom to hear the sentence related to a case against him that unfolded in July 2013 at a Citgo gas station in Detroit. Officer Notoriano, accompanied by an off-duty Detroit police sergeant, confronted 2 men, pointing a gun at them while using racial slurs. Officer Notoriano faced multiple charges for the incident, including armed robbery and racial intimidation. Watch how the encounter unfolds.
There were no winners at all in this situation, not only for myself and my family, but for all of those involved.
Every single thing he's done as a police officer exemplifies everything we want in a police officer.
Be a deterrent to others who might think to act in that way.
Judge, he's not the same man that he was on July 21st, 2013.
Officer Michael Notoriano was sentenced to 6 months in jail for his role in a violent confrontation stemming from his daughter's stolen cell phone. Although a jury acquitted him of most charges, he was found guilty of willful neglect of duty by a public official, a misdemeanor. If you think this was the last of cops reacting to death sentences, then you probably aren't aware of this next case.
throughout the night with the test and everything. So, and it's based on my judgment and my experience that I've had over the years that I believe that he was under the influence and he wasn't safe to be on the road, which is why he was placed under arrest.
This is Officer Oliver from the Eddyville Police Department. On February 16, 2022, Officer Oliver showed up at a court hearing where he provided testimony regarding the DUI arrest of 65-year-old Mr. Fernandez. Despite training from the National Highway Traffic Safety Administration indicating that individuals over 65 should not be subjected to standard field sobriety tests, the officer administered them and noted only one clue of impairment, insufficient under guidelines to determine intoxication. However, the officer relied on personal judgment and experience to justify the arrest, arguing that signs of intoxication vary. Watch how he gets pulverized in the court.
Examination, you were asked and you stated that people exhibit being under the influence of alcohol differently based upon your career, your training. Explain that to the jury. Explain what you mean. Clarify your answer for them, please.
When you're dealing with all kinds of different individuals, depending on level of intoxication, frequency of how often that person may drink, everyone reacts differently to being under the influence. Some people may not be able to drink as much as someone else and show more signs. And like I said, I've had individuals that I remember specifically that could go into the jail, blow into the toxilizer, blow 3 times the legal limit, and could walk and talk just as well as any of us. When in this circumstance, when we have someone that does not offer a blood alcohol sample, when they refuse that, we have to go based off of our judgment as to what we see them doing throughout the night with the test and everything. So, and it's based on my judgment and my experience that I've had over the years that I believe that he was under the influence and he wasn't safe to be on the road, which is why he was placed under arrest.
And Shannon, Your Honor, may we approach?
The officer just refused the blood alcohol test. We moved for a mistrial and a dismissal when you mentioned it. I don't contest that point. Yeah. Okay. I will declare a mistrial. And a dismissal. I won't declare a dismissal. Dismissal versus the mistrial. I will declare mistrial. The Commonwealth elicited the testimony, Your Honor. Oh, I did not. I specifically said we're not going to mention that word. I don't believe that was it. I will declare mistrial. I'm not going to dismiss. But I do believe you're entitled to a mistrial based on that statement. Okay. Thank you, Your Honor. Officer Oliver, you may be excused. Based on the motion from Mr. Foreman and Mr. Bates, the court, after hearing the testimony, I do declare a mistrial in this case. So thank you, members of the jury, for coming here today and being a part of this. Unfortunately, a resolution cannot be reached in this case. This case will need to be retried in front of a new jury. Thank you for your time.
The court identified procedural issues, including the need for a thorough investigation into the passenger's sobriety and the absence of video evidence at the holding facility. Addressing these concerns and challenges to the officer's credibility, the judge declared a mistrial, emphasizing the importance of ensuring a fair trial. It's shocking to see cops who are meant to protect us get sentenced for their heinous crimes. If you enjoyed this video, make sure to drop a like and subscribe for more. Goodbye.